Obviously the main issue is crime and trying to prevent it and or deter crime from happening. How I would address that is to remain tough on drug dealers, on violent criminal offenders, and obviously those repeat offenders where nothing else works. I intend to, if elected, continue alternative courts to try to reduce our crime. In my experience and in my opinion, a lot of our citizens suffer from either mental health issues or drug issues, and a lot of times they go hand in hand. So if you only address one, it doesn't solve the problem. So by having mental health court as well as drug court, hopefully we can identify root causes of crime and fix the problem at its root, instead of continuing to send people to the Department of Corrections, not getting them any treatment, and then as soon as they're released, they reoffend. In the juvenile realm, similar. I see a lot of juvenile offenses involving drugs and alcohol. I know that there's a lot of drugs and alcohol in our junior high and high school. I would do a combination of education of children of the effects of drugs and alcohol. I think we need to start early, like 4th, 5th grade, instead of waiting until they're in high school, because they start earlier and earlier. I think if we educate them enough, maybe they would choose not to try it until they're of age. If they do and they become addicted, then I think juvenile drug court is also a good option. It's worked well with adults, and I think we owe it to our juveniles to try drug court. State's attorney is the advisor for the county board, and I would ensure that I'm prepared for county board meetings. The current state's attorney's office is, in my opinion, not organized. The attorneys, some of the attorneys are not trained or given the support that they need in order to do their jobs. There's one attorney in the office who is highly experienced, however he only works part-time. And right now the case assignment in the office is between the two felony assistants, even and odd, which doesn't make a lot of sense to me, because one of them is full-time and is there 5 days a week. The other is part-time and is there a couple days a week. In my experience, and in my view, I would keep the part-time attorney because he's the most experienced attorney dealing with some of our most serious cases. And to provide continuity to those cases, I would obviously extend the offer to him to stay. I can't force him to stay if he doesn't want to, but I would definitely extend the offer. If he decided to stay, I would have him focus on those cases. I completely believe in a team approach to prosecution and jury trials, as well as a team approach just in general. And if I'm elected, I'm going to require my attorneys to work as a team and not be me, or this isn't my case, I'm not handling it. That attitude doesn't fly with me. I don't know if I agree to reducing it. However, I do agree that diversionary programs, where appropriate, can help reduce that. Again, it goes back to identifying the root problem and addressing it as soon as possible. Obviously, for a Class C misdemeanor offense, the maximum penalty is 30 days in jail. If it's their first offense, they're not going to go to jail anyway. Mm-hmm. Generally, we don't look at jail sentences until there's nothing else we can do. But I honestly think that our system misses a lot of the key problems. And for instance, I represented a defendant recently who went through juvenile court and has been convicted of crimes in adult court. When I was appointed to him, I raised an issue of fitness, and he was found unfit and sent to the Department of Human Services for treatment. And now that he's back, he's a completely different person. If someone would have identified that while he was a juvenile and addressed it appropriately, maybe he wouldn't have had to be convicted of the crimes that he's been convicted of. Obviously, you can't guarantee that that's not going to be the case, but I feel that with appropriate treatment, a lot of the crimes that we have are going to be reduced, if not eradicated. Number one, I have extensive trial experience in both civil and criminal cases. I've tried 33 cases either before a jury or before a judge. 19 of those were felony cases. 6 of them were DUI cases, and 6 of them were misdemeanor cases. I may be missing one. Oh, one was a mental health commitment. So obviously I have a wide range of experience in different areas. Some of the felonies that I tried were serious felonies, predatory criminal sexual assault, and aggravated criminal sexual abuse, and possession of child pornography. That was as a 7-11, so I wasn't completely licensed, but I sat second chair in it and participated in the trial.
And how did you come to choose a career in law?
Oh, that's an interesting question. When I was going to college, my major was industrial relations, human resources. As a prerequisite, even to get into the business program, we were required to take business law. Business law didn't just focus on business issues, but talked about torts and contracts and a little bit of real estate. Obviously, even if you go into corporate law, you're definitely going to be negotiating contracts, and you're going to be potentially entering into real estate transactions. It didn't really deal with criminal law, obviously, although there could be a component of criminal law in business as well. And businesses can be charged with torts, so it's all kind of intertwined. So in addition to taking my business law class for the IRHR emphasis major, I was also required to take labor law legislation, which goes through the Civil Rights Act of 1963 and all of the employment-related laws, the ADA, the Americans with Disabilities Act, and how they apply to hiring and firing, that kind of thing. And we actually analyzed cases in that class. We had a case book. We'd have to read the case and analyze it. When I graduated, I had the option of applying to do a joint degree where it would have been an MBA and a Juris Doctor joint. I had considered that, but decided I wanted to get out into the real world and work for a while. Being a new graduate, I had probably an unrealistic view of the ease of obtaining a job in my area. Unfortunately, it was in the late 80s, and a lot of companies were downsizing their personnel department or their HR department. So there wasn't a lot of jobs available. There was a lot of competition for the jobs available. So after about a year, I decided I wanted to try to go to law school. I applied to 2 schools and didn't get accepted at that point. So I continued to work with Hy-Vee. I went through their management track. I was in the management training program and got through 3 different departments trainings. I was on course to become an assistant director, because at that point I was a food store manager, which meant that I basically ran the entire grocery department, and then I had 1 assistant. when I decided this is not for me, I'm going to try law school again. So I took the LSAT again. I applied and got accepted to 4 out of 5 schools and decided to come to Northern Illinois. I'm a full-time mother, I'm a full-time attorney. I'm also involved in our community. So if I can do those 3 things and run a successful practice, I feel I am the most capable, organized person to run the office. I also feel I have a lot more experience than my primary opponent. And I believe my organization is much greater than his, and my effectiveness and ability to get things done is more effective as well. I don't like to let cases linger. My view is the quicker that I can get something resolved, the better it is for everyone, including the court system.